We can start now. Good afternoon, good morning, good evening, wherever you are. Welcome to the fifth webinar of IDEA Vietnam Chamber on International Trade Arbitration. In this webinar, we would like to introduce to you Ms. Sherlin Tung, a partner of Arbitrators Worldwide. She is a partner in International Arbitration and Litigation team based in her Hong Kong office. She is a specialist in cross-border corporate and commercial dispute, with a particular focus on joint venture shareholder dispute and many other, including Cisg and multi-jurisdictional litigation. Sherlin acts as counsel, sits as an independent arbitrator, and also as expert on international arbitration procedure. With over a decade of experience, Sherlin has advised clients in the APAC region, America, Europe, and on first aspect of international arbitration and litigation. Sherlin worked for the leading arbitration institution, the ICC, International Court of Arbitration, managing over 300 international arbitration matters in both Hong Kong and New York. The latter of which, where she was founding member of the Case Management Office. Sherlin has also served as an arbitrator in international arbitration matters. She regularly speaks in conference as well as give lecture and training worldwide on international arbitration, trade law, cross-border dispute. She is a registered foreign lawyer in Hong Kong and is qualified to practice law in New York and California. She is native in Mandarin Chinese and English, and in proficient in Spanish and controversial in German. Welcome, Sherlin, to Vietnamese arbitration community. I assume that this is the first time for you to speak to Vietnamese lawyer, right? Now the floor is yours.
Thank you very much. I think I do have to thank all of you, and thank you in particular for the invitation. It is the first time that I've spoken in front of the Vietnamese legal community, and hopefully not the last. Vietnam was actually one of my favorite countries to visit prior to COVID. And I remember we were back in Vietnam in 2017. And we had wanted to go back soon thereafter, but everything happened. But don't worry, I'm working to make it on my list. So let me go ahead and start off, because I know that today we're kind of giving everyone an introduction on international trade law and how it's going to coincide or the interrelation with international arbitration. Whenever we talk about international trade law, or at least me, I usually like to associate that with, of course, the CISG. So let me go ahead and share my screen now. I'm going to apologize to everyone in advance. I always have a tendency to have technical issues. I know we've tried this already, and we know I can share. There's the sharing. And I'm supposed to hit the share screen, slideshow. There we go. If there's something wrong with the screen, or if there's something wrong with my slides, somebody feel free to tell me. And as I mentioned during our prep before this, always happy for any interruptions or questions. That includes from the audience. If you have questions, please go ahead and put them in the chat. As you can see, again, my name is Sherlin Tung. I'm a partner with Withers. Withers Worldwide is our worldwide name. Interestingly enough, I know that this firm is probably not as well known in, for example, Vietnam. When I first joined 2 years ago, I had never heard of them. And then as soon as I joined them, I discovered that Withers has been around for over 125 years. We've got 24 offices worldwide, but our commercial disputes team is still quite young. We were first established in international commercial disputes in about 2014. That's when we established the international arbitration practice, and that's probably why our name isn't as prevalent. But hopefully after today's webinar, everyone on this webinar will love Withers and you will spread the word. You are always welcome to stop by our offices in Singapore and Hong Kong and Japan if you go visit. But let's go back to what we are here to discuss today. And what I'm going to start with is kind of an outline. This is where the next half hour or so is going to take us, hopefully. I'm going to start with an introduction on what the CISG is. Then I'm going to go into the application of the CISG. Then I'm going to go into a bit of a background on the CISG in the APAC region, basically Asia Pacific region, focusing on Vietnam for reasons obvious to you, and also for Hong Kong, because that's where I'm currently based. But Hong Kong is also quite interesting for everyone to learn about because of the fact, and we'll get into more details later on, Hong Kong, which is technically, or which is a part of China, we are a special administrative region of China, always had a question of whether or not the CISG applied or was extended to Hong Kong due to the fact that there was a handover in 1997. I'll go into a little bit more detail on that because that ambiguity has now been eliminated and there's a clear way forward, but it's an interesting history. And also it developed an interesting amount of case law that counsel and parties worldwide can still rely on. Next, I will go into why you should choose the CISG. Now, don't let the title of this trick you because technically speaking, sometimes it's not a choice. And I'll explain also why in this section, but I will explain the benefits of the CISG and why we believe that this is actually, there is good reason as to why this is one of the most successful international treaties in relation to international case law, contract law, sorry. Then we'll go into the CISG and arbitration, basically the interrelation between the two. And finally, I'll touch upon CISG and practicalities, maybe what you as a legal counsel should know for yourselves, as well as for your clients, as well as for those of you who act as independent arbitrators or perhaps judges who have to deal with issues of the CISG. So what is the CISG? The CISG is basically, it's the abbreviation for the United Nations Convention on Contracts for the International Sale of Goods. It's basically a multilateral treaty, which is also known as the Vienna Convention. Now, the CISG basically was developed by the United Nations Commission on International Trade Law, whom we all know as UNCITRAL, back in 1968. Now, the history behind this is that the CISG is actually rooted in two earlier international sales treaties, which were first developed in about 1930 by the International Institute for the Unification of Private Law, which is also known as UNIDROIT. Unfortunately, neither of these treaties gained widespread global support. So UNCITRAL basically drew from the existing texts and developed what we now know eventually as the CISG. The CISG took a long time to draft because mainly there was a lot of different stakeholders involved. It involved nonprofit organizations, lawyers, academics, and everything from all over the world, because the entire the purpose of the CISG was to draw this unified legal text for international contract law. And the first draft of the CISG was actually submitted to the Conference of the International Sale of Goods, which was held in 1980. But you can see that the CISG didn't actually come into force until 1 January 1988. So from when UNCITRAL first started developing the CISG in 1968, it took 20 years to enforce. Now, when the CISG was enforced, initially 11 countries had ratified it. And those countries are Argentina, China, Egypt, France, Hungary, Italy, Lesotho, Syria, United States, Yugoslavia, which is no longer a country, and Zambia. But as you can see, it's quite a wide and diverse group of countries that ratified it initially. But as of today, we have far more than 11 countries. Now, the CISG aims to facilitate international trade. It basically establishes a uniform framework for international commerce. It removes legal barriers among trade between contracting states. And it's a provision of uniform rules that govern most aspects of an international commercial transaction. Now, as I mentioned, we've come a far cry from 11 countries. As of 2022, we have the CISG being ratified by 95 countries. And this represents more than 2/3 of the global economy. Now, among the list of these 95 countries includes APAC's top economies, such as China, Japan, Singapore, and the Republic of Korea. And what is important to note, maybe you guys aren't yet one of the largest economies, but you are a significant economy in Asia, and Vietnam is also a country that has ratified the CISG. Now, the CISG is known as the most successful international document in unified international sales law. There are parties that are represented from every geographical region. It goes into play and takes into consideration every stage of economic development, and every major legal, social, and economic system was taken into consideration when the CISG was drafted. The CISG technically is drafted in plain English, although I know that sometimes it is still difficult to read and understand completely, but the intent behind the CISG was to avoid words that were associated with specific domestic legal nuances. So for example, in the US, you often hear about the parole evidence rule. That specific terminology would not be found in the CISG because the CISG's purpose is to encompass an international approach. The CISG also comes in 6 official languages, and those are the 6 of the official languages of the United Nations. So you can find the CISG in Arabic, Chinese, English, Russian, French, and Spanish. You can also find translations of the CISG in various other languages, but these are the official languages of which they are published. Now, here we're going to turn now to the application of the CISG. Why, how and why would the CISG be applied? So first, just to understand the CISG governs the following aspects of an international sale of goods contract. For example, it covers contract formation, offer acceptance, the rights and obligations of parties. It also covers the remedies for breach of contract, passing of risk of the goods, and exemptions from liabilities. Now, it is important to note that the CISG only applies to contracts for international sale of goods. So they don't apply to certain contracts such as for services and other things that we will get to later on. The contract of the sale technically must be international. It is defined as between parties whose places of business are in different states. And places of businesses generally mean where the party usually trades or is located. It's not necessarily what the party's nationality is. Now, purely local transactions are not within the scope of the CISG, but later on, I will also touch upon how that isn't necessarily the case. In particular, if it comes to party agreement to apply the CISG in a dispute that is submitted to international arbitration. That doesn't work. There we go. Now, so as I mentioned earlier, there's certain things that the CISG doesn't cover. And one of those examples is that it doesn't cover contracts that are purely for services. It also doesn't apply to contracts for goods that are intended for personal, family, or household use, unless the seller neither knew nor ought to have known that the goods were bought for any such use at any time before the conclusion of the contract. The CISG also doesn't cover contracts by option, contracts that are executed otherwise by authority of law, contracts for stocks, shares, investment securities, negotiable instruments, or money, contracts for ships, vessels, hovercrafts, or aircrafts, or contracts for electricity. Now, the CISG, when does it apply? Well, it is automatically applied if it is incorporated into the domestic law of contracting states. It is also automatically applied if and is applicable to sale of goods between parties with places of business in contracting states. Now, it's important to note that contracting parties can also decide to opt out and exclude the CISG from application to their transaction, even if the governing law is, for example, of a domestic law of a contracting state. A party can also expressly include the CISG as the governing law to their contract. And parties can also decide to modify the rules that are established by the CISG in their contract. Now, why is the applicability important? In particular, for example, for arbitrations or even in courts. Oftentimes, and as practitioners, we know that the governing law clause isn't necessarily completely thought out. If you've got an international transaction between, for example, China and California, each side is going to want their domestic law or whatever law that they are familiar with to apply. Now, there are situations where, for example, the parties will agree to a particular domestic law, thinking that their domestic law, for example, China, would apply. But because of the situation, if it's between a Chinese party and a party in the US, if the applicable law to the contract is Chinese law, because it is a sale of goods contract between a Chinese party and an American party, both of whom are contracting states to the CISG, it isn't actually going to be domestic mainland Chinese law that's going to apply. It's going to be the CISG that applies. So in that type of a situation, the application of the CISG is automatic. And if you are a judge or if you are an arbitrator sitting in a dispute, that's something that you should be made aware of or you should be aware of. Now, looking at the CISG in the APAC region, I mean, we're all here. We know that the world has seen an impressive growth in Asian economies over the past decade, even with the onslaught of the COVID pandemic. Now, a lot of these countries and regions in the APAC region have close trading partners to what we like to call the West, so the US, Europe, etc. Now, there's an increasing need for uniform or harmonized law in these commercial matters because because of the fact that these various international parties are still not familiar with the other side's laws. Now, there's the number of Asian contracting states to the CISG are still limited, but we are seeing many developments in case law. Now, with the more recent developments of the Asian countries ratifying or having the CISG extended to their jurisdictions, we're starting to see a lot more support or a lot more case law backgrounds and consistent law and how international transactions will be perceived. So for example, the adaptation of the CISG by Hong Kong will greatly assist Hong Kong businesses in connecting with and smoothing any dispute resolution with their trading partner in the region and in a worldwide context. So we just I also wanted to give you a list of the recent ratifications of the CISG in Asia. And of course, I start with Vietnam. On 18 December 2015, Vietnam ratified the CISG, but the CISG, to my understanding, only came in force in Vietnam as of 1 January 2017. On 1 January 2019, the state of Palestine ratified the CISG. 1 April 2020, we had North Korea. 1 October 2020, we had Laos. Hong Kong technically didn't ratify it, but the CISG was extended to apply to Hong Kong, and that will take effect as of 1 December 2022. And as of 1 June 2023, the CISG will take effect also in Turkmenistan. So as you can see, we're slowly starting to get more and more countries in Asia who've ratified the CISG. Singapore ratified the CISG before Vietnam did. Now, looking at the CISG in Vietnam, and basically we're looking at certain parts of the law that is applied by both the CISG, or certain parts of the law and how it would come out if it was under Vietnamese law and how it would come out if it was under CISG law. I'm clearly not an expert on whether or not the Vietnamese law is accurate, so I will rely on Dr. Nguyen or anybody in the audience to correct me if there's anything wrong. Also happy to answer any questions if it comes to be the CISG. But if we look at, for example, suspension of contract performance, under Vietnamese law, the party is required, to my understanding, to perform its obligation first. The party required to perform its obligation first has the right to suspend contract performance if the other party's ability to implement its obligation is severely impaired. Now, under the CISG, a party may also suspend performance of its obligations if it becomes apparent that the other party will not perform the contract. And this is under Article 71 of the CISG. In relation to specific performance order, under Vietnamese law allows the aggrieved party to apply for a specific order of either repair or replacement of the defective goods. Whereas under the CISG, the buyer can always request a repair of goods, and this is Article 46.3, but delivery of substituted goods can only be requested if a fundamental breach, as defined by Article 25 of the CISG, has occurred, and this is 46.2 of the CISG. Now, the CISG is, in its nature, makes termination or avoidance of the contract a very, very high threshold. Generally speaking, you need to have a fundamental breach under Article 25 of the CISG in order to void the contract. Generally speaking, under Article 25 of the CISG, a three-pronged test is actually set out. And so, as you can see, the difference with the CISG and Vietnamese law, the delivery of substitute goods is not necessarily already a remedy for a party. You literally have to meet the standard of a fundamental breach before you can even request it. Looking at damage compensation. So under Vietnamese law, compensatory damages include the actual and direct loss which is suffered by the other party due to the breach and the direct profit the aggrieved party would have earned. Under the CISG, damages consist of a sum equal to the loss, including loss of profit, which is suffered by the other party as a consequence of the breach. Now, the emphasis for damages under the CISG is on the foreseeability of the loss. And damages under the CISG are covered under Articles 74, 75, and 76. We can take a more detailed look at damages under the CISG later if we have questions on this. The next topic that we wanted to take a look at was on the interest rate on the refunded amount. So under Vietnamese law, a party is required to pay interest on the unpaid amount, which is corresponding to the late period. Whereas under the CISG, if a seller is required to refund the price of the contract, then they can be bound to pay interest to the buyer from the date on which the contract price was paid to the seller until the date of which the seller returns the contract price to the buyer. And this is covered by Article 84.1 of the CISG. Turning back to a bit more familiar territory for me, the CISG in Hong Kong. What's interesting to basically speak about is that it's the history of the CISG. I don't go into specific laws and the differences between CISG and Hong Kong law, but looking at the path at how the CISG is now extended to Hong Kong really helps to support why the CISG is good to apply in contracts and why parties should probably, parties in international trade relations should consider the CISG as a governing law. So as we heard earlier, China is actually one of the 11 initial countries to ratify the CISG when it was passed in 1968. But given the fact with China's status as a contracting state, this resulted in a lot of academic debate as to whether or not Hong Kong was deemed a party to the CISG. Because China ratified the CISG in 1968, at the time, Hong Kong was not a part of China. At that time, Hong Kong was a part of the UK. When the handover applied in 1997, it was unclear as to whether the CISG was also extended to Hong Kong. And for a long time, it remained uncertain as to whether the CISG applied in Hong Kong. And in fact, if you take a look at case law, you've got cases from all over the world going both ways. For example, in the New York State Department of Health versus Rusi Technology Limited, the court there found that yes, the CISG applied to that dispute or it extended to Hong Kong. Whereas in Logicom versus CCT Marketing Limited, the court went the other way and said no. So there was a lot of debate at the time. There was a lot of questioning. There was no certainty as to whether or not the CISG applied, which also takes away from one of the main benefits of the CISG, which is implementing uniform law for international contractual relations. Now, on 29 September 2021, Hong Kong's LegCo passed the Sale of Goods Ordinance, which basically sought to implement the CISG in Hong Kong. The Hong Kong Department of Justice envisaged that the CISG ordinance would come into force around the third quarter of 2022. They were close. The CISG will now be extended and the CISG ordinance will take place in effect in Hong Kong as of 1 December 2022. Now, the interesting thing about Hong Kong's declaration of the CISG or Hong Kong's version of their CISG ordinance, contrary to China, the Hong Kong courts will also apply the CISG not only under Article 11A, but also under Article 11B. This is different from mainland China's application because mainland China is only under 11A. Now, let me go about why is that important? Why is the fact that Hong Kong courts will apply the CISG under Article 11A, but also 11B? That's because under 11B, if one of the parties to an international sale of goods contract does not come from a contracting state of the CISG, if the law governing the contract is Hong Kong law, because of the fact that it is an international sale of goods contract, the CISG will actually apply. Now, the ordinance's implementation is actually good news to Hong Kong, and we like to argue that it is good news to other countries that have implemented the CISG. It's especially helpful to small and medium-sized firms because the CISG will protect local businesses from being subject to unfamiliar foreign laws when entering into cross-border sale of goods transaction. It also provides the communities and the companies with an additional choice of law. Now, it's important to note if you've got clients who do business with both Hong Kong and China, or perhaps you have clients in one of the other that will do business with the other, the CISG does not automatically apply to domestic transactions between mainland China and Hong Kong. In the past, They have been applied to such transactions and arbitrations, and there are pending plans for a mutual arrangement to be established between the two jurisdictions. As I mentioned earlier, the CISG will come into effect in Hong Kong as of 1 December 2022, and the reason for that is because on 4 May 2022, China declared to the CISG depository that the CISG shall apply to Hong Kong. And more key benefits as to why having the CISG is beneficial for the companies. It's an additional option, for example, for Hong Kong traders regarding the governing law of their sale of goods contracts with businesses in other CISG contracting states, where Hong Kong law is used as the residual law. For example, many major trading countries are CISG contracting states, and this applies to all countries worldwide, since more than 2/3 of the jurisdictions worldwide have adopted the CISG. The application of CISG to Hong Kong also has the potential to facilitate GDP and trade growth. And again, we would argue that this also applies to other countries in Asia that have the CISG that have ratified the CISG. Now, the cons of having the CISG ratified so late, or at least the cons of having the CISG clearly ratified in Hong Kong so late is that now we're changing the status quo of the existing standard contracts and its associated costs in light of the CISG. But we don't believe if for countries that have ratified the CISG earlier than what we have, there's not going to be the similar cons or similar issues. Now we go to why choose the CISG. Again, sometimes, like I said, you don't really have a choice. For the examples that were given earlier, sometimes the CISG just already applies in a contract if you've chosen a domestic law that already encompasses the CISG. But why is it good to have the CISG govern an international sale of goods contract? There's neutrality, there's consistency, there's stability and certainty. The CISG is an international treaty, is one established work that can be, or that has been contributed by many jurisdictions worldwide, and it isn't favorable to any particular jurisdiction. It's a law that's going to be familiar to all parties that are involved. It is easily accessible and something that can be learned even after it's been chosen. The CISG will prevail over domestic law, and it helps avoid complicated conflicts of laws issues. The CISG can also be applied flexibly. As I mentioned earlier, parties can decide to derogate or modify certain provisions in the CISG by including it in their contract. The CISG also provides legal infrastructure to assist a government's drive to encourage economic expansion by providing companies and businessmen with a uniform international sales law with the companies that they are investing in. So there's no requirement that you have to go in, a party has to go in and learn all of the laws of the other side. The CISG provides the uniformity and consistency. There's more trade and shipping related arbitrations that could be resolved according to the CISG based on experience. And also by learning the CISG, you can enhance local lawyers' competence in managing and handling CISG related disputes. The CISG is also beneficial for countries along the Belt and Road because it gives a greater potential to serve as a dispute resolution hub for members of the Belt and Road Initiative. Now turning to CISG and the interrelation with arbitration. You see the benefits often. I mean, the benefits for both using the CISG and also utilizing international arbitration as a way to resolve your disputes are very similar. We go back to neutrality, we go back to consistency, and we go back to flexibility. Disputes in relation to international trade are actually often resolved by means of arbitration. And you apply the CISG in an arbitration when there's an express reference to the CISG as the governing law, when there's an express reference to the law of the contracting state, or the arbitral tribunal can also determine that the CISG is the appropriate rule or appropriate governing law based on all of the factors that are provided by the parties or existent in the dispute itself. The CISG can also be used from a procedural aspect of an arbitration. So there's been case law, and there's been more and more support in the recent years that the CISG can also be the law that's applicable to the arbitration agreement. There's no dispute that the CISG can also cover the merits of an arbitration. Now, one thing to be careful of, or just for the avoidance of doubt, Parties who wish for potential arbitration to be governed by the CISG must and should include their preference in the arbitration agreement. So one thing that I was touching upon earlier, the benefit of having the CISG and utilizing it in arbitration is that with party autonomy, even if certain things don't apply, for example, if you've got one or two parties that are not from a contracting state, you can still, as a party, agree with the other side to have the CISG as the applicable law to your contract or to the substance of your dispute. And you can do that in international arbitration because one of the benefits of international arbitration is party autonomy. I think all of this is something that I just all went through, so I'm going to skip. Coming now to the practicalities, expectations for legal counsels and arbitrators for arbitrations governed by the CISG. Now, we've already harped on this. CISG applies automatically between sale of goods contracts between contracting states, unless there's an express opt-out clause. Now, when you draft to exclude the CISG, the language has to specifically rule out the application. So for example, if parties to international sale of goods contract that is governed by the laws of Hong Kong, they would have to say this contract is governed by the laws of Hong Kong, excluding the application of the CISG. If you miss out on that last part of that provision, and this contract is an international sale of goods contract, and it involves a party from Hong Kong and any other international party, because it is governed by the laws of Hong Kong, and assuming that this contract was entered into after 1 December 2022, the CISG would automatically apply by default, because Hong Kong law at that point will have incorporated the CISG. Now, it's important to note that arbitrators in particular, they're bound by the parties' agreement. So if the parties have chosen the law of a contracting state to govern substantive issues of the dispute, the arbitrators should apply the CISG as an implicit choice of law. Failing to apply the CISG would result in the award possibly being challenged. Now, there's been a lot of discussion on how you can actually force an arbitrator to abide by this particular situation, because as we all know, generally speaking, in international arbitration, there's no appeals mechanism. International arbitration is the only way to challenge or set aside an arbitration award, they're very limited. And it doesn't actually allow for a party to appeal a decision as they can do in the national courts. So the question or the criticism that has often arisen is, so what happens if the arbitrator gets the law wrong? Well, the benefit of being a small international arbitration community is if an arbitrator were to get it wrong, it would be quite widespread. The community would be aware, the arbitral institutions will be aware. If it is at an extent where it is so against public policy, that award can and would be challenged or set aside at the seat of arbitration or at a relevant court of jurisdiction. So we can rest assured that the arbitrators will perform at the level that they're expected to, and also listen to party autonomy. I think that's it for now. If you have any questions, I think hopefully you do. Happy here to answer, but I believe that there will be a commentary.
Thanks, Sherlin, for excellent presentation. I think before going to the Q&A discussion, we should listen to Dr. Nguyễn Trang, who will make a comment on the Vietnam market, how is application in the Vietnam, right? Trang, so the floor is yours.
Yes, thank you, Sherlin, for a very comprehensive speech on Cisg and also sharing your experience on how Cisg is applying in all over the world, especially Hong Kong. With regard to Vietnam, I would like to share some facts about how Cisg could be applied in Vietnam. But first, I want to share that some facts about the markets, the sales of goods situation in Vietnam. You can see that the main partners of Vietnamese parties are from China, US, and Korean, Japan. All of them are contracting state of Cisg. So we really expect that when Vietnam ratify and participate join Cisg, we will have more contracts which Cisg will be governed. However, and also the situation of the dispute resolution by Vietnam International Arbitration Center, VIC, so that there are a huge number of disputes related to sale of goods contracts. So it's around for the recent 4 years, there are around more than 50% of the dispute resolved by VICs related to the sale of goods contracts. And therefore, when Vietnam became a party of Cisg on 2017, we believe that we will have more contracts. We believe that there will be more dispute where Cisg could be applied. But that's our expectation. And this is the reality, the facts, that from Cisg database, there's only 5 cases that could be resolved by arbitration in VIC. Only 5 cases was applied Cisg. 1 case was applied by the court in Ho Chi Minh City, the appeal division of the Ho Chi Minh court. But such case is very, very long time ago, from 1996. So maybe such contract could be applied Cisg because parties expressly agree that Cisg could be applied. Whereas the 5 case in VIC that I showed you related to that is around 2019, 2020. So it's very recently, but for 5 cases compared to a very huge number of contracts that we expect, it seems that parties in Vietnam, or maybe the partners of Vietnam, does not really favor Cisg. Is it the truth? Actually, in my opinion, it's not the truth. One of the reasons maybe that contract was concluded before Cisg took effect in Vietnam before January 2017, but I don't think that is the main reasons, because with the numbers of partners and the value of the imports and exported goods that Vietnam deal with the other partner, it seems that we will have hundreds or even thousands contracts with other parties from member states of Cisg. So the second reason may be that when parties have a choice of law clause, normally when you say that the mere reference to the stating law like Vietnamese law, for example, could not exclude Cisg from its application in the contracts, but the situation in Vietnam is different. So if in the contract parties say that the applicable law is Vietnamese law, normally the courts and the arbitral tribunal will interpret that such is an exclude choice of laws, of substantive law. And therefore, the Vietnamese law will be applied rather than Cisg. You don't need to expressly opt out for Cisg in Vietnam. The second reason is when there's no agreement on choice of law, so that the parties does not have choice of law clause. In such case, normally we think that the arbitral tribunal will fill the gap by applying the Cisg, but in Vietnam the answer is no again. In such case, normally the parties in Vietnam who does not know about Cisg much, and therefore they're afraid of applying Cisg. When submitting their opinion, their claims, or their arguments, they only based on Vietnamese law or the national law of their normal law. Like if they are from Singapore, they will base on Singapore law. If they are from US, they will base on US law, for example, rather than Cisg. And in such case, the arbitral tribunal may be afraid to step out to say that no, this because you don't have a choice of law clause, then Cisg should be applied. The the submission based on the Vietnamese law or another national law could be an implicit agreement of the parties that they do not want to apply Cisg. And therefore, if the arbitral tribunal apply another law rather than the law submitted by the parties, they maybe exceed the mandate and they're afraid that their award could be challenged in the future. And that the reason, I think that that's the two main reasons why Cisg could not be applied in Vietnam as what we expect. With regard to Cisg and the law on commercial arbitration, law on commerce in Vietnam, actually, Ms. Sherlin also had some comparison with regard to this matter, but I want to emphasize that with regard to the form of contracts, Vietnam make a reservation when they ratify Cisg, and that the freedom of the form will not apply in Vietnam when you have a Vietnamese party. So if you have a deal with Vietnamese party, please remember that the contract should be in written form with the seal, the company seal, and the signature of the legal representative. Otherwise, in the future, when the dispute arises, your contract could be declared as null and void by the Vietnamese courts or the Vietnamese arbitral tribunal as well. So this is what I think that the most important things you should bear in mind. I also provide some useful links where you can have the Cisg text, the commentaries, and case law. You can also research related to Cisg. And I hope that my short comments on Vietnamese law, Vietnamese practice of Cisg could be helpful to you. Thank you.
Thank you, Dr. Trang, for your comment on the application of Cisg in Vietnam. Yeah, actually, I also have some surprise why Cisg has been ratified by Vietnam. As not much case appear in the domestic arbitration. I have said in an arbitration tribunal about, I think, a year ago, when the party refer in the same contract, international same contract, that the applicable law should be Vietnamese law and including any international law. And when the channel try to reconcile with the parties that if they refer to Vietnamese law, that it means that it also includes the Cisg. But both parties object that idea, and they say that now this is a domestic law, not the Cisg. Cisg is an international law. So that case, we have no choice but to comply with the party wish, and we have to include the Cisg. So that is the practice in Vietnam. I also understand that among our participants, few participants who also have experience in the Cisg arbitration, and I would like to invite one to share experience with us. Is Nguyen still here? I saw the name of Nguyen. So, Link, can you open the mic for Nguyen? Trần Thắng Nguyen. Yeah, Nguyen Trần Thắng. Can the host open the mic for Nguyen? Hello, Nguyen. Can you hear me? Hello? I'm not so sure if she's still on. Yeah, she's on mute. Can you unmute? Or someone, the host, can you unmute? Link, can you unmute Hoàng? No? I cannot hear you. All right. We have Samatha Matthew here who raised hand. So can you open the mic for Samatha? I'm sorry for technical problem, but yeah, Samatha, yeah. Samatha, are you online now? Yes. Yeah. Hello.
Oh, can you hear me?
Yeah, I can hear you clearly.
Good morning. I'm sorry, I'm with my smartphone only, so this is a little bit, yeah, inconvenient. Thank you so much for the great discussion. I was raising my hand because I was concerned about maybe the person you wanted to talk to cannot interact, as I could not interact with you either because there is no chat function open.
Oh.
That was my first point that I wanted to say. So maybe
Okay.
you can read
So
out
sorry.
on the person.
Yes. I think we ask the host to open the chat function. Yeah, but Samantha, do you have anything to share with the audience about any experience in the CSG arbitration?
Yeah, well, the CISG arbitration, it is very useful, especially for common law cases. This is what I had been experiencing. And the efficiency, of course, of international dispute resolution with CISG is, yeah, recommendable too. You have clear outlining, very good procedural outsettings. And yeah, I wanted to ask Ms. Sherlin Tung about her experiences between regarding the void, yeah, the reason to put a contract void after following the Vietnamese law. This was something that I was interested in, especially. Yeah, and also I would like to understand whether in private setups such as like tourism related contracting for opening a hotel, for instance, and staffing, CISG clauses could be recommendable or not, in Vietnam especially. Is this something that you are having experiences with, good or positive or negative ones? I would be very happy to know about that then.
Thank you,
because
Samantha,
I think
for your question.
I don't know. Maybe you can tell me specifically regarding hotel business in Vietnam. Thank you.
Okay. All right. Thank you for your question. I think Dr. Trang would be the right person to answer this question, right? Trang, can you answer right now?
Sorry, but could you please rephrase your question?
I think actually, so Trang, it's going to be a little bit of a combination between the two of us. I'm not even going to try to attempt to answer the question under Vietnamese law because that's where you're the expert. But what I can try, and Samantha, please correct me if I've misconstrued or if I've completely changed your question so that I am able to answer it. And unfortunately, Trang's not. So my understanding, one question was whether or not we can use the CISG, or is it beneficial to apply the CISG in a contract, for example, when you're for hotel business in Vietnam. Well, it depends. I heard part of it. I remember part of that question being staff, and I will be informed if I'm wrong because I've got a CISG expert listening on the side. But if it's for pure contract of services, employment, CISG won't apply because the CISG is to apply only to the sale of goods. But if it's for example, sale of goods to establish the hotel, whether it be the equipment or I don't know, I should know this better. I've had a couple of hospitality cases where there were disputes. They had nothing to do with the actual hotel itself, but more the construction of the hotel. But the CISG can apply to certain aspects for the sale of goods to that hotel to establish the hotel. I know another question was with respect to fundamental breach and how it was applied with Vietnamese law. That I can't answer, but I can answer. Samantha, go ahead, your hand's up. Am I close?
Yes, thank you, Sherlin. I did not want to interrupt you though, because you're in the flow. But yeah, just to put some more detail inside, it's about reconstruction of a hotel, which has been very fine and beautiful traditional house, but there has to be a lot of reconstruction on a basis of sustainability. So the UN SDGs is the bottom line for having like sustainable energy I'm sorry, I'm a little bit confused because I have two children here in the background. So they have to insert new pipelines and so on. So the whole refurbishment has to be under the sustainability aspects. And so it is, of course, also having a lot of construction moment. Let's put it like that. But let's say there.
Sorry, Samantha, I'm going to interject really quickly. Is there already a contract?
Oh no, there are not contracts yet. There are some contracts, probably old contracts, old contracting, and this is something that has to be considered as being put void, maybe.
Well, so, okay, now I get the voidance of the contract question. Okay, so there's this tricky part, right? The CISG really is supposed to only apply to the sale of goods. You get all the time in real life practice a combination contract where you've got sale of material, sale of goods, whatever you want to call it, also services. And that's where the line gets tricky, because if the services part of, well, first, the CISG doesn't apply to services. But when you have a mixed contract, now the question is whether or not the CISG can even apply to the contract itself in relation to the sale of materials and everything. And you need to look at, basically, there are various ways of calculating it, but you know, is the contract more sales? Is the contract more services? I mean, if you don't have a contract yet, separate that, because then you know for a fact that the sale of the materials can be covered by the CISG. You'll get this uniform law that you'll be familiar with, rather than a law that you're unfamiliar with. And in relation to the actual services part yourself, you will get wonderful expert advice from Dr. Trang on how it would be applied under Vietnamese law.
So it is possible to trace everything into a CISG format, even though there are pre-existing other contractual bottom lines. Sorry.
Okay. You never need to apologize for being a mom. But I do need you to rephrase that question a little bit.
Well, I mean that, so if we understand that there might be some contracting in the bottom line, which cannot be just put void, and there's no way to apply CISG on, how could it be maybe ruled out in a later competition between CISG and prevailing Vietnamese law? Would that be possible? Do you think so? That's what. Is it possible to have kind of like a mix, but then the parties agree to rule under CISG?
Well, if I may sum up that, I think that you could still apply or agree to apply the CISG, and in case the provisions of CISG is not clear enough, then, for example, the Vietnamese law or any other law that parties agree could be applied to fill the gap that CIG could not fill in. And the second thing is that if under CIG, the matter could not be governed, like CIG does not have any provision on the time limit, for example, for you to raise the claims, then Vietnamese law could also be applied in such case. So the express agreement on the application of CIG does not mean the exclusion of Vietnamese law when you have a dispute with the other party. So you don't need to like an agreement on a clearly agreement that CIG and Vietnamese will be applied. You only need to say that CIG could be applied. And then when there's no provision, no relevant provisions of CIG could be applied, the courts or the arbitral tribunal could still consider other national law to apply in your case.
So you have the freedom of contract to choose freely within your contractual situation, right?
To an extent, yes, but you also have to look at now, how are you resolving that dispute, right? So if you end up, if you're willing to enclose or include an arbitration provision in your contract, and I know that my answer is biased because I am a specialist in arbitration, but one of the fundamental features of arbitration is party autonomy. So you get that benefit of extra flexibility. So as with Nguyen, as long as you don't exclude anything, the parties have a choice to decide what laws will apply. But for example, if you include a provision that requires court litigation, or if you don't include a dispute resolution provision at all, it defaults to court. National courts tend to be bound by a bit more of a strict framework, right? For in their eyes, they would likely, if you go to Vietnam, apply the Vietnamese law unless the parties are able to argue why the CISG applies. Whereas if it's the other way around, you go to arbitration and you also put in your contract, the parties want this to apply, the tribunal usually will respect it unless there's a reason. For example, it violates a mandatory law or it goes against public policy. They will respect the party's choice.
Okay, totally.
Thank you, Samantha.
So,
Thank you so
much.
Thank you, Samantha, for your attendance. Now move to the next question for Sherlin. There is a question: what is the benefit for the seller to having the CSG applied to the same contract, and conversely, what is the benefit to the buyer to having the CSG applied to their purchase agreement? I assume that the CSG is the balance point between the seller and the buyer. Is that correct, Sherlin?
I mean, if you ask me, I would say that both sides have benefits of having the CISG apply. It's not one-sided, given that it's been worked on by so many different jurisdictions. I think for me, the benefits of having the CISG apply for both the seller and a buyer is that both sides are familiar with what will apply to the transaction. Both sides are familiar on the standards of proof. The CISG is drafted in a way where they try and avoid the ability for parties to terminate or avoid a contract. The reason behind that is because the CISG is meant to try and encourage parties to carry out the international sale of goods contract until to the point where they can no longer do it. If I could just interject really quickly, I was supposed to give some recommended reading. So for those of you that are listening, there's so many books out there on the CISG, but there's this one website that I would suggest. It's CISG-online.org. This website basically has pulled together every single case law that it can find, which is probably most or if not all, whether it's in the courts or arbitral awards, that has the CISG as the governing law or has some aspect of the CISG involved in the court or court decision or award judgment. The website also allows you to search for cases by jurisdiction, by issue, by article. The website also has a lot of helpful information on the CISG itself. It lists the CISG Advisory Council opinions, and there's advisory council opinions on various different article provisions. For example, articles 74, 75, and 76 which deal with damages. Many other articles, including an article, Samantha, that you might want to look into on mixed contracts of services and sale of goods. So this is probably where I would start if you need secondary reading, and you can get all the case law and you can get all of the valid provisions. Sorry, but back to why the CISG is beneficial. That is why I think it's beneficial to both sellers and buyers.
All right, thank you. Then another question to you is, please identify what constitutes a fundamental breach under CSG, and any note for party when drafting a sale of good contract to avoid risk. Can you give any practical tip?
So fundamental breach is defined, fundamental breach under the CISG is defined by Article 25. As Americans, we like to always have these tests developed, and we always like to argue Article 25 actually sets out a three-pronged test for what constitutes fundamental breach. So first, there needs to be a breach of contract. Second, it's fundamental in that it results in detriment to the other party. And third, that detriment has to be so substantial that it deprives the non-breaching party of what it is entitled to expect, so a foreseeability prong. So that's what I would say. That's basically the plain wording of Article 25, but go to the Advisory Council opinions and also look on that website, and you'll see cases that are described worldwide in court judgments and everything that determine what is actually a fundamental breach and what is just not a fundamental breach.
Thank you, Sherlin, for your explanation. The next question, I think, is for Trang. CSG went into effective in Vietnam 2017 and more than 5 years. What aspect do you think CSG could benefit the most in practice for Vietnamese enterprise?
Yes, I think that one of the most important benefits that CSG could bring to for the Vietnamese enterprise is that they bring a standard, an international standards for both the buyer and sellers, so that you don't need to deal with your partner that which law will be applied. You have a tools here, you have an international tools here, an international standard here, and therefore parties understand understand well their obligation and rights in CSG. You have tons of case law, the explanation, commentary, so that you can easily to explain it. Whereas for if you want to apply national law, for example, Vietnamese law, there are lots of vague things in Vietnam. Even the provision in Vietnam, we have the guidelines, we have the decree to clarify it, but still it's still arguable. But for CSG, a lot of things was clarified, and you have a lot of case law to apply. And because more than 90 states are member state of CSG, and therefore they also prefer to use something that they are more familiar with, like CSG, and it's easier for you to have contracts with other partners like that.
Thank you. So do you think that Commercial Law 2005 of Vietnam should be updated in line with Vietnam ratifies CSG or not?
Yes, for my in my opinion, the answer is yes. It's the Commercial Law was issued like 2005, so it's more than 50 years now. It's quite long compared to other law. It's better to have to have it updated so that it could be more in line with CSG. It could still keep some provisions more specialized, but still, I think that it's better to update it.
All right. Just a thing, I do not really understand that mainland China is, I think, the largest import partner of Vietnam, because Vietnam import lots of things from China and then export it to the Europe or US. So, but we cannot, or we do not witness any lots of transaction involving the application of CSG. So what about the international trade between mainland China with other trading partner? Do you see the same thing? Because I said from the beginning, Sherlin said from the beginning that China is one of 11 initial signature, right, of the CSG. And I also see in the CSG website there's a few CITAC arbitration award as a case law for the application of CSG. So how do you think about that?
Yes, sorry.
Yep.
So I have to be honest, and with a lot of my cases that I've seen in contracts involving mainland Chinese counterparts, oftentimes we see the CISG being expressly excluded, even if the law governing the contract is mainland Chinese law. One of the reasons for that is because, and I mean, this was from before, because a lot of these contracts were from a decade ago or so on, but it's because parties or in-house counsel aren't really familiar with, or they don't understand the CISG. As we slowly start to educate legal counsel, external legal counsel or in-house counsel about the CISG and its benefits, I started to see more and more contracts where the CISG will be implemented. But up until now, I've had a couple of cases where mainland Chinese law was applied and it was a CISG and they were all arbitration matters. But again, I've seen a number that's been excluded, and that could also be why. That's why it's also very important to educate the community on the benefits of the CISG, because like you said, with China and Vietnam being such, doing so much business together, I can't imagine any of your clients wanting mainland Chinese law to apply. And I can't imagine any Chinese client wanting Vietnamese law to apply. But the CISG is your common denominator, right? Both sides have ratified the CISG, and the CISG is a familiar law for both parties. And if you add another layer of neutrality and stick it in arbitration, I really think that, you know, I mean, obviously parties don't like to think about the dispute aspect, but if you ever do get to that point, you will have a neutral law and you will have a neutral forum.
All right, thank you. It's it's clear. I recently sit in the SIC arbitration on international interest, and I'm a little bit surprised to see the party to submit the ICC arbitration awards as a case law for the application of the CSG. And I note that you have a substantial time to spend with ICC in Hong Kong and then New York. So why the ICC arbitration award should be a good sort of the case law for the application of the CSG? Do you know?
So it kind of depends. So the ICC has this ICC DRL, this dispute resolution library, where they do publish excerpts of their awards. And I mean, with that website that I just explained, that I just relayed to you guys, and I hope everyone has written it down, because these ICC excerpts or these awards that involve the CISG as the governing law, you will also be able to find it on that database. But prior to when this database was established, or when it became more prevalent, it was really difficult to find arbitral awards where the CISG was the governing law. And the ICC, because they did publish excerpts of awards, that's how parties could find how the CISG was applied in arbitrations. So I guess hopefully the party that submitted an ICC excerpt where the tribunal, the governing law was the CISG. And again, as you know, because you have significant experience as an arbitrator, it's not binding, but it does show how another arbitral tribunal, when presented with an issue under the CISG, how it was applied. So we see this all the time at the ICC for the awards that are published. And I mean, now the SIAC, HKIAC, they are all starting to also publish awards, obviously with anything confidential blacked out. But the more publications we see now of arbitral awards that have CISG as the governing law, I think the more you're going to see submissions of those awards in arbitration matters as legal support.
Right. Very interesting to hear about that. Okay, I cannot see any other question here in the chat function. Perhaps the audience, if you want to have any question to the speaker, you can write in the chat function, or you just put on the raise hand box, so we can invite you to speak directly to the speaker. Yes, I don't see anything more. Yeah, I have a question. As I just I have written to you that regarding the damage under CSG, and you can see that we have the different damage regulated by Article 74, 75, and 76, right? So, is it usual for the party to submit alternative claim in their submission in their case, or should the party just select the one or two most important thing or most convincing damage to ask for the tribunal to decide? Because in our domestic arbitration, if the party submit so different damage asking for the tribunal to decide, alternatively, it may prove that that party not very strong or not very persuasive in their own argument. So what do you think about that? What do you think the International Arbitration Tribunal will assess?
So for me, what I always tell my clients is we obviously and should always put forth alternative arguments if they have merits. You will piss off an arbitral tribunal, as you know, sitting as an arbitrator, if you throw a lot of superfluous, worthless arguments before the tribunal. However, if there is some merits behind the case, you should always put them out as alternative arguments. In particular, though, however, in relation to the damages claim, and I think I had sent you a response back on that. Yes, if you can raise all of them, you should, as long as you've got the support. But Article 75 and 76 require first voidance of the contract. So if that's not something that you are searching for, by the plain wording of the articles, I mean, I would argue that you probably shouldn't raise it. There are other people with other thoughts. If you look at publications and everything out there, or even there's an advisory council opinion on it, where they say that it doesn't necessarily have to, so 75 and 76 doesn't necessarily need a avoidance of contract, but I'm also very plain reading of a provision. 75 and 76 start off with avoidance of the contract. So for me, if my client were to try to argue that, but they weren't trying to void the contract, it just wouldn't make sense. But again, it goes both ways. There are people that will argue the other way.
All right, good. And the last thing I would like to consult with you as an international arbitrator is it's not easy for a Vietnamese party to select an arbitrator on their own case involving the CSG application. If you see the panel of the arbitrator in every institution, you will see that so many arbitrators claim that they can handle every kind of the dispute involving international chess. So how or what kind of criteria which will help the party to choose the right one for their own case?
That's also something difficult to look at, but you're absolutely right. When I worked at the ICC, so just to make clear, the ICC does not have a list of arbitrators.
Yeah.
The reason that they say, the reason why they do that is because the ICC is very big on party autonomy. So they don't want to give the parties the impression that they are limited to nominate an arbitrator from a particular list. Just to point out, most arbitral institutions, it's the same thing. You're not limited to appoint an arbitrator from their lists, but they do still have lists. HKIC, SIC, ICDR, they all have their own lists. The ICC specifically does not do the list because they are always looking out for new and young talent. But then at the same time, between you and everyone who's on this chat, the ICC has an internal list. It really does. So every time that you've been appointed or you've been nominated to act as an arbitrator, they have an internal database, and the ICC, their national committees or the secretariat will go into this internal database at times and reach out and approach arbitrators. Now, for those of us who don't have the benefit of this internal database, you're right. How do you select an arbitrator? Because everyone says that they can cover everything and they're experts in the field. For in-house counsel, I would say rely strongly on your external counsel's experience, because the international arbitration community and the trade community is actually quite small. So as I mentioned in my presentation earlier, while there's no definite way to make sure that the arbitrator will get the law right, there's so many repercussions within the field. For example, if their award gets set aside or overturned, or the lawyers in the case all realize that the arbitrator went the wrong way with the law, that will spread, in particular in the legal community. So rely heavily on your legal community. But also, you know, for example, if you look at trade law, if you need somebody who's an expert on the CISG, I would start with the advisory council, because there you go, you've got the foremost experts on the CISG who have been asked to gather together on this advisory council to give opinions on the CISG itself. Now, from there, you'll see publications from academics or from practitioners. So do your research, and you can see who actually publishes and speaks on certain topics. You can also start to see if you, again, trust your legal counsel, because they'll know the reputation of individuals. And also talk to arbitral institutions. They will know best because they've got the ins and outs.
All right, we see a hand raised by Mr. Phan of PCI Legal, I think. The host, can you open the mic for Mr. Phan? Yeah.
Can you hear me?
Yep.
Okay. Thank you. I have a question.
We cannot hear you now. Tang, can you repeat it? You are mute now. Can you unmute yourself? Or the host, can you unmute him?
Okay.
Yeah.
Can you hear me now?
Yes.
Okay. So my question is there any circumstance that make the choice of application of CISG void or unenforceable? Thank you.
I didn't actually hear all of the question.
Can you repeat your question?
Yes. So my question is there any circumstance that make the choice of CISG, the choice of application of CISG void or unenforceable?
Do you mean in the form of the final award?
Yes.
So if an arbitrator were to apply the CISG, and technically the arbitrator shouldn't have because it was the wrong law, would the award be unenforceable?
I think that his question related to like the validity of the contract, of the validity of the choice of CISG clause actually, rather than the arbitral awards. So I think that it will be the same circumstance when the contract could be null and void, like for the capacity of the signatory, the person who signed the contracts, or the form of contracts, for example. So if the contract is null and void, then the clause, the choice of law clause, which refer to CISG, could also be null and void.
Oh, I would argue no. But I mean, that's an interesting, so my understanding, can the choice of the CISG as the governing law make a contract void if the CISG cannot apply to the contract? And if that is the question, I mean, as a lawyer, I would argue no, because then that just means you go through a complex of law analysis, and you will determine what law is applicable to the contract. But I can't see an argument where if the parties agree to, for example, the CISG for the contract of services, which the CISG can apply to, I can't imagine that making the contract itself for the services be void.
Yes.
Okay, the next question for Trang. Is there any conflict regarding the interpretation ability of arbitration agreement between Vietnam law on commercial arbitration, civil code, and the CISG? Alternatively, if a contract is covered by the law of Vietnam, could the Cisg be deemed to apply to the arbitration agreement as well?
Now, this is a very interesting question. As Ms. Sherlin also present in her presentation, that actually could still be applied to interpret the arbitration agreement to some aspects. But talking about it, then if you are a Vietnamese arbitral tribunal, then normally the arbitral tribunal and Vietnamese courts will only rely on the LCA or the civil courts, the interpretation principle in the LCA or civil court to interpret the arbitration agreement rather than CISG, because as you may know, whether CISG could be applied to interpret the arbitration agreement or not is still arguable. But if you have a civil court and there's an expressly choice of law that the civil courts or Vietnamese court, Vietnamese law will be applied, then the courts and the arbitral tribunal normally will apply Vietnamese law to interpret the arbitration agreement.
Is there any difference in Hong Kong, Sherlin?
So in Hong Kong, now that the CISG is being incorporated into Hong Kong domestic law per se,
Yeah.
I think if they apply Hong Kong law, but it's what international parties, the CISG will apply.
Right. All right. I think we has answered all the question. Yes, and new. No, nothing new. No new question here. Audience, if you want to ask anything to our speaker, please write down on the chat function or just simply raise hand. Nothing. So, all right. So, what your practical advice to the practitioner in Vietnam about the Cisg arbitration? What your recommendation to them?
I think so. The practical advice is definitely familiarize yourselves with the CISG. I believe that the implementation or the use of the CISG in particular in arbitration is going to increase because we're seeing a rise in spite of the COVID pandemic. International business relations continue to increase. The sale of goods, international sale of goods continue to get higher or continue to increase and become more, and more countries are reaching out and doing business with one another. More countries are ratifying the CISG. So for me, the advice with your clients are always include an international arbitration clause and a familiar arbitration institution, and familiarize yourselves, don't exclude the CISG when you enter into the sale of goods contract. Don't deprive yourself of a consistent and a law that everyone is familiar with, in particular yourselves.
Yeah. Trang, what's your recommendation to our colleagues?
Well, I think that before I had some comment or recommendation about this, I think that it's better to add one point, because the topics of this webinar is international trade arbitration. So besides CISG, you could also consider many rules from business association, like we have International Cotton Association, we have the Grain and Feed Association. So there's a lot of business association, and there's also arbitration under these rules, like ICA or GAFTA, and you could consider it when you have a specific goods to sell to other partners. And therefore, in such case, CISG could still be applied, but the rules of this association will be prevailed because you have specific agreements on those. And another thing is that they also have the list of arbitrators. You could also consider the arbitrators in the list of such associations. The third thing is they also have some measure to prevent the parties who does not comply with the arbitral awards. like some prevention or blacklist. They could also announce your name in the blacklist. And actually, because I have some experience related to the recognition and enforcement of foreign arbitral awards in Vietnam, like about more than 10 ICA arbitral awards, and the same with the GATCA awards. A lot of Vietnamese enterprise fail to comply with the arbitral awards. Even though they try to resist the enforcement before the Vietnamese courts, but their names still be put in the blacklist of the association, and therefore it will definitely damage your reputations and also the reliability of the partners, of your business partners in such case. This is something that you should consider when you decide to follow or respect your contracts or not. And therefore, before you decide to sign a contract, be careful with all of the clause what's included in the contracts. For example, the choice of laws clause, the payment terms, the quality and quantity terms, for example. And if you don't know or could not know about this, then maybe you will prefer to use Vietnamese law, something you're familiar with, but the other surely would not accept your choice. And CIG could be one of the best solutions for both of you. And this is why Vietnam wants to become a party of CIG as well. So in such case, if you could not agree with your parties, with your partners that Vietnamese law apply, then try to argue that CIG will be applied. And if you want CIG to be applied, then please, even though Sherlin say that it will automatically apply, I would recommend that please write in your contract that CIG will be applied to the transaction to prevent any circumstance like in Vietnam. If you did not specify that CIG will be applied, then the court will not apply CIG for you.
Thank you, Dr. Trang, for your advice and recommendation. Thank you, Sherlin, for your time with us. And I hope that you will be getting better, and we will have time to visit you, or you will welcome your visit to Hanoi or Ho Chi Minh City, wherever you like. Right? We have to stop here because it's 3:32 and we cannot keep the speaker longer. I would like to thank all the speaker, all the audience who joined with us, and the next webinar sit time next week on Friday is on the M&A arbitration with the participant of the Mr. Matthew Secom, Dr. Matthew Secom, and the local commentator is Mr. Nguyễn, the head of our arbitration practice. And we would welcome you again sit time next Friday. Thank you all and goodbye.
Thank you guys. Have
Good
a
night
great
weekend.
weekend. Bye.
Good night weekend, Sherlin.